I get a lot of clients where let's say I'm representing husband, and let's say that husband had or was responsible for taking on a lot of the debt from the community. So the debt was in husband's name, he's ordered to pay it back. In this situation, wife was ordered to pay husband, let's call it $50,000. It was a total of $100,000 of community debt. So husband's going to pay that back to the creditors after the divorce. The idea is that wife's going to pay husband $50,000. And the hypothetical I want to pose to you is, let's say wife comes to you after they get the divorce decree and says, I want to file for bankruptcy. My questions would be, is it possible for her to get the debt discharged from the divorce decree, and sort of what would that look like in dealings from the bankruptcy perspective?
Really, we're looking at what the decree says, right? There's different types of awards, child support, alimony, and when we're talking about this equal payment for the debt that the husband's going to assume in this scenario, generally they're going to be classified as an equalization payment. You know, the bankruptcy code says that you can discharge unsecured debts. It depends on which chapter of bankruptcy you file. So just real quick recap, there's two different consumer chapters that our office handles, which is Chapter 7 and 13. In either scenario, or pardon me, in Chapter 7, you're never going to discharge alimony, child support, or an equalization payment, which is what you're describing. However, there is a section in the code that says in Chapter 13, you can actually discharge equalization payments. It just depends on if it's for a secured buyout for like a home, or if it's classified ostensibly as alimony or child support. In that case, you wouldn't be able to. But if it's for the assumption of debt, there's a good chance you might be able to discharge that in a Chapter 13.